Look around. We'll go there for some reason. Remain in your seat and present that to us if you would.
Thank you, Mr. Chairman. We're back with a revised proposed substitute to House Bill 204, which provides for exchanging of opposing affidavits if they are to be used in motions. The first part under Section 1 applies to affidavits opposing or supporting a motion other than motions for summary judgment, and it simply provides that such affidavit, if used, shall be served at least one business day before. We simply added that word business day to keep from serving an affidavit on Sunday or something of that sort. Then under Section 2, this was the harder issue, I think, which is to come up with a schedule that works in exchanging affidavits supporting and opposing motions for summary judgment. And so after a lot of collaboration, we've come up with this plan, which is that, as always, we just are explicit in stating that a motion for summary judgment may be decided by the court without a hearing, unless the hearing is requested. But if a hearing on motion for summary judgment is permitted, if a written request for a hearing is filed with the motion, it can be filed with the motion or within 5 days of the filing of the response, and that is in conformity, I think, with 911-6 and the local rule. It says, if a request for a hearing is timely filed, a hearing shall be held not earlier than 45 days from the date of service of the motion for summary judgment. Opposing affidavits, if used, shall be served not later than 7 days before the date set for the hearing. So the goal here was to give a party 7 days time to see what's in an affidavit and prepare for the hearing based on what's in the affidavit. So you have 30 days after the filing of the motion for summary judgment to respond to it. You can request a hearing up to 5 days later, so that would get you out to day 35. Then you've got 3 days there that are sort of fudge days before you're counting back from your day 45. So between day 35 and 38, those are the days when you could be working to get and serve your motion, your affidavit in support or in opposition to your motion for summary judgment. So it gives everyone more time than we had before, gives everybody time to prepare for what's in the affidavits supporting or opposing summary judgment, and I think for purposes of judicial economy, prevent people from getting there on the day of or the eve of a motion for summary judgment that's been set, hearing on that's been set for a long time, and have a late breaking affidavit be a game changer.
All right. Anyone in the audience wish to address the committee on House Bill 204? Yes, sir.
I'll just be very brief, Mr. Chairman.
All right.
Support this substitute. I think the representative's done a good job of working through the various issues, and we appreciate your work.
Thank you, Mr. Clark. Anyone else? If not, we'll close off further public input on the bill. Any comments, discussion among the committee members? One thing I will be sure we to address this publicly, the Uniform Superior Court rules are where we have the requirement for the 30 days time from the time of the filing of the affidavit to the time of the earliest date for a hearing on motion of summary judgment, correct? No? Mr. Jacobs?
I'm going to defer to Mr. Jacobs to answer that question.
No, Mr. Chairman, that was actually in 911-56C.
It is.
And it's been struck through, but what you have in the Uniform Superior Court rules is the 30-day time period for serving a response to the motion.
That's it.
And then I will say that what we have here in Section 2 of the bill is a very nice marriage of the Uniform Superior Court rule and Representative Beskin's objective of having the hearing set no sooner than 45 days from the date the motion is served.
Okay.
And that the affidavits be served at least 7 days out from the hearing.
Thank you. Any further discussion among the members of the committee? If not, the chair will entertain a motion.
Do pass, Mr. Chairman.
Motion is to do pass. Do we have a second? There's been a second. Is there any further discussion? Any amendments? There being none, the chair will call the main question. All in favor of do pass signify by saying aye.
Aye.
Opposed, like sign. We have House Bill 204 passes a committee substitute, correct? All right. I'm going to call on Ms. Quick next, her House Bill 405. Ms. Quick, you want to come up, please, ma'am?
Thank you, Mr. Chairman.
You have somebody with you, too.
And if I could, Mr. Chairman, Rebecca Reeder is here with me as the chair of the State Bar Family Law Section, if she might
Thank you.
come
Thank
up.
you, Ms. Reeder.
She's my boss on this bill, so this is
Okay.
a State Bar bill.
That's good. We'll let you go forward then.
Thank you, Mr. Chairman and members of the committee. House Bill 405, as I said, is part of the 2015 State Bar of Georgia legislative agenda. And this started out with a focus by the State Bar Family Law Section actually just on 19362 in an effort to remove an antiquated term, which is marriage articles, and to try to create consistency between marriage articles and marriage contracts from an attestation standpoint, to require witnesses there, and to also require that antenuptial agreements be in writing. And so, as so often happens when you delve into this and you start dealing with this, it became a little bit more complicated than that, and I'll go through the bill and thank just publicly Jill Travis for her work on this with me. It took us several months to go through not just the portions of the statutes that needed to be revised and dealt with, but also then to go through the bar process and dealing with the section and so forth, and decisions to be made about how it should be handled from a practitioner standpoint. So I appreciate her work on this. I'll just start on the first page of the bill. In Title 13, marriage articles are an exception to the statute of frauds, and so this would delete that and require that antenuptial agreement be in writing, which I think many of our colleagues were surprised to find out that anything that could be called a prenuptial agreement could be oral. So I think from a policy standpoint that requested change makes sense. The next change on the second page of the bill in 19360 is an effort to actually define antenuptial agreement. It was not defined in code, and so that is where we have started here in 19360. Moving forward, 19362 is where the meat of the attestation changes, the execution formalities. We're requesting that the law be changed so that an antenuptial agreement be in writing and attested to by at least two witnesses, one of whom shall be a notary public. Again, that's another decision to be made, whether it should be shall be a notary public or may be a notary public. And as I understand it, this matches the execution formalities for a deed, and so we're requesting that it be a shall. The next change is to mirror that, which is on line 59 of what I'm working from, which I hope matches up to the subcommittee substitute.
296478S.
That's the subcommittee substitute, and I didn't get a copy of that, Mr. Chairman. I'm sorry, but
Down.
if I could.
We'll get you one.
And I apologize to the members of the committee. I'm fighting whatever's going around the Capitol. I'll try not to cough in your ear.
Could you sit over there?
It would be lines lines 59 and 60 of the substitute, again, that's the change to require that one of the witnesses shall be a notary public. And so the balance of the bill really was an effort to take a look at an antiquated procedure of this recordation with the clerk of Superior Court that no one could remember ever doing in their practice. We talked to practitioners who've been doing this 30 plus and 40 years. No one had ever recorded a prenuptial agreement with the clerk of Superior Court. There was not a separate docket maintained at any of the clerk's offices that we checked with. And frankly, because these prenuptial agreements require so much personal financial information, no litigant in their right mind would really want to record a prenuptial agreement. And so when you see all these strikes in the code section, it is to modernize and update this particular process, which in actuality no one was following. I supplied to the committee, at least I think it might have gotten into your folders, the Fox versus Fox case, which is an explanation of how some of the confusion has developed in the Supreme Court cases between this distinction of what is in contemplation of marriage and in contemplation of divorce. And the memo that I gave you also explains this and explains the basis for the change. But that's just a general overview of walking you through the bill and what it does and what the State Bar is asking the committee's consideration in a due pass.
Thank you, Ms. Quick. Any questions of Ms. Quick at this point by members of the committee? One question I have is we're defining now the term antenuptial agreement. I notice we removed the other term we had, which was marriage articles, and we don't have prenuptial, only antenuptial as far as a term. Is there a need to have further definitions with regards to contracts that are made either in contemplation of marriage or after marriage?
I don't believe so, Mr. Chairman, because the terminology utilized by the Supreme Court and utilized by the statute now matches up. The antenuptial agreement, the marriage contracts, that they've called those in contemplation of divorce, in contemplation of marriage.
Yeah.
So I don't see the need for further definition. I'll defer to Ms. Reeder if she feels differently about that, but I think in terms of the way at least the terminologies are used in the statute, Ms. Travis is pretty well always on me about defining what needs to be defined, and I hope we got it.
I think you're right. Ms. Reeder.
Yes, sir.
Would you like to give us your thoughts on this bill?
We fully support the bill. This has been a problem that obviously through the Superior Court cases in 2009 and 2012, the last being Fox versus Fox, is still a current issue. That this comes out of antiquated code law that was last changed in 1981, which was the year before Shear versus Shear, which is the seminal case in Georgia, which provides that prenuptial agreements are not against public policy and provides a clear and definitive three-pronged test as to their enforceability. It's antiquated into the fact that women didn't used to be able to have property rights, and therefore this was an ability for women to protect their separate property when entering into a marriage.
Very well. Any questions of Ms. Reeder by members of the committee? This went through the family law section of the State Bar.
Yes, Mr. Chairman, it went through the State Bar family law section and then went through the State Bar process and is fully supported by the State Bar.
Okay. Anyone else wish to address the committee on the House Bill 405? If not, we'll close all further public comment. The bill is now in the breast of the committee. Any discussion among committee members? If not, Chair will entertain a motion.
You pass, Mr. Chairman.
Motion is due pass. Do we have any discussion? Second on the motion? Any discussion on the motion? Any proposed amendments? If not, Chair will call the question. All in favor of the motion due pass signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you.
Thank you also for calling me before Representative Hightower. I know he can sometimes get convoluted with things, and I appreciate that.
Perhaps you're right.
Thank you, Mr. Chairman.
Thank you, too. We're going to call next the House Bill 347. Mr. Hightower.
You want to stay up and help me out with this?
House Bill 347. Hightower, let you
Afternoon, Mr. Chairman.
lead out.
I'm good. You signed on to it.
I'll say if you want.
No, you're good. Mr. Chairman, I was kidding with Representative Quick. She actually signed on to this bill and helped me with this bill. So,
All right, ready?
Chairman's pleasure.
Proceed.
All right, Mr. Chairman, just going through this, this bill actually goes to clarify some language that was thought to be pretty straightforward before. But let's just focus on lines 11 through 16 first. If you look on line 11, we strike through of child support and add in judgments rendered pursuant to Title 19. And really that's just to clarify and make this code section a little less redundant because if you go down to end of line 14 through line 16, we strike this code section shall apply to all awards, court orders, decrees, and judgments rendered under Title 19, which included child support. So that's really just a clarification just to make it so the code section is a little less redundant. The substantive change that we did add was on line 13 where it deals with those type judgments. We did say that a judgment is entered or an installment payment is due as applicable. The court may modify the date on which interest shall begin to accrue. So we gave the courts a little bit of leeway there. Which actually was mirroring the largest change and what this bill was really getting to, which is on lines 32 through 35, which says that essentially that in order for someone to collect interest on alimony or equitable division of assets, it shall not accrue until an installment is 30 days past due unless otherwise ordered by a court. I'll answer any questions, Mr. Chairman. What this was in response to is there were attorneys that were trying to make arguments and get people to pay interest on alimony payments when there weren't active court orders out there, and this just specifically says that no, if you're going to try to get interest on an alimony payment, then it needs to be court ordered.
How would they be getting interest on alimony that are out there? Just wouldn't there be an award, temporary award of alimony as opposed to a judgment?
Well, I'm not sure if I can.
I mean, you file an action for divorce. You have a hearing, not just child support, but the court can award payments of alimony on a temporary basis.
They can.
Oh yeah. And if they do that, there's a failure to pay those temporary awards of alimony. Would this take away the ability to have the award made to include interest for failure to pay?
I don't believe so because it says in here, it says until an installment is 30 days past due unless otherwise ordered by a court. If you go on the back side, Mr. Chairman.
Yeah, I'm looking at something.
Mr. Chairman, some of the confusion was caused by, I think when this code section was set out originally, it was really meant to deal with child support, but then it had that crazy language on line 15 and 16 that said it applied to all of Title 19, and that's where the confusion came in. So that's why the language on page 2 is to clarify when you're dealing, because child support can be awarded many different ways in Title 19, but maybe that reference of blanketly saying Title 19 was a little broad, and so that's why page 2 is necessary to clarify when you're talking about alimony and equitable division.
I just said the concern is we do recognize there is a award of temporary alimony as an addition to child support. So I don't know if we need to recognize alimony or child support being awarded on a temporary basis as a part of the language in the act. Mr. Weldon, do you have a question?
I'm going to waive. Thank you, Mr.
All
Chairman.
right. Questions of the members of the committee of the presenter? Nothing further?
Nothing further.
Is there anyone else in the audience who wishes to address the committee on House Bill 347? If not, the chair will close all further public input. And you can remain if you would, because we may have some questions of you. Mr. Weldon?
Thank you, Mr. Chairman. And to the author of the bill and esteemed counsel, I've seen judges award lump sum alimony and then provide that the payments should be made in a certain period of time, over a period of time to pay that sum. Can you just address the issue of how, I guess, lines 32 through 35 might have an impact on that?
They would not be able to collect interest on those payments unless it was specifically ordered by the court, or unless someone was late on their payments, or their payments were 30 days past due. Then they could get interest on those payments. All this is saying is that on an alimony an award of alimony, the judge has to directly award interest in the order. If not, once you're past 30 days past once you're 30 days past due, then interest will be allowed to accrue, which mirrors the language. We'll just did the 30 days. If you look back on 13, we just made it uniform to match 30 days in front.
Even on the lump sum that's awarded?
Should work the same way.
Okay. Thank you.
Yes, sir. Any further questions of the committee? Well, the chair has concern what I just raised about the matters of temporary awards, and I think we might want to, I'm asking perhaps Ms. Travis to look at that. We may hold up further consideration on the bill till we address the issue of the temporary awards of alimony and child support is probably already addressed. I'm not sure we have addressed the issue on, well, I say it's addressed. We talk about awards, and of course we talk about awards as being a temporary order of the court, perhaps.
Mr. Chairman, if I would, as far as the child support, we shouldn't have changed very much to child support in this portion. Well, we just clarified language, so we shouldn't.
I realize we took out the term of child support as referencing awards, and I'm just not clear.
With all Title 19, which covers child support. So
we also struck through the line saying this code section shall apply to all awards, court orders, decrees, and judgments rendered pursuant to Title 19.
And yes, Mr. Chairman, and the reason we did that, if you'll look again, line 11 said all awards of child support, and then it went down, which it said all awards of child support. Then this is what Ms. Travis was trying to get to a while ago. Then it went down and said this code section shall apply to all awards, court decrees, judgments pursuant to Title 19. Well, child support is included in that. So what we did is just struck that and moved up and said all awards and judgments rendered to Title 19. It was redundant before, and we just made it so it's not redundant anymore. So we really should not have changed anything there, just made it so it didn't repeat itself.
My concern is that the courts may look at saying, well, what is included by meaning of awards? A child support award, or is alimony looked upon as being a type of, quote, award? We don't have award to define. And I know we talked about earlier the only being awards of child support. Then we said everything else as awards, court orders, decrees, judgments pursuant to Title 19 being applied by this section. And that's where I was just having a little bit of a hang-up. Does that make sense, Ms. Travis?
Well, I don't know the difference between, frankly, I don't know what the difference is between a judgment, a court order, a decree.
Well, that's the judge.
And award. I think they're all the same. Yeah, that's the judge.
Well, that's the point of the judgment usually is recognized as a final rendering by the court.
Right, right, as opposed to a temporary order.
Correct.
Well, Mr. Chairman, if we changed all awards, if we just moved that up, and
we said, well, wait a minute, please. Mr. Welch.
Mr. Chairman, if you would like to, review the bill further, that would be fine. Or, I could offer that we would insert, after all awards, we could add court orders and decrees and just recapture the language that was struck in lines 14 and 15 and 16.
That's what I'm asking for.
And move that into line 11. And I think that would preserve all the language that was in the current code.
Correct.
It would keep it in this. We just reorganize it. That's all we would do.
All right.
I'm fine with that, Mr. Chairman.
You fine with that? Okay.
Yes, Mr. Chairman.
That all right with you, Ms. Travis?
Yes.
Thank you.
Thank you.
All right. That's a good suggestion, Mr. Welch. And members of the committee, yes, sir. Mr. Jacobs?
Just a query, does that same language then need to be replicated on line 32? Where we speak only to judgments? Probably not, but.
I don't think so. That would be, again, recognizing, I think, a final judgment of the court as opposed to what we're looking at up here as under paragraph A, the temporary awards that may be made as well as judgments.
The two read exactly the same anyway.
Yeah.
That's correct, Mr. Chairman.
Anything further, Mr. Jacobs? And I think I asked if anyone else in the audience wants to address the committee on House Bill 347. If not, we'll close off further public comment. The bill is now in the breast of the committee. Any discussion among the committee members relative to House Bill 347? If not, the chair will entertain a motion. We have a motion due pass with a second. Further discussion of the motion or amendments? Mr. Welch.
Mr. Chairman, I have an amendment. If the chair will allow at line 11, after the words all awards, insert a comma and include court orders, comma, decrees. And that's my amendment.
No, won't be another comma. Be court orders, comma, decrees, and judgments rendered. Right?
It'll read
all awards, comma, court orders, comma, decrees, and judgments rendered, etc. Is that right?
That's right, unless Ms. Travis thinks I need a comma after decrees.
You need a comma after decrees.
Do you?
Like it is on line 15.
All right.
Okay.
That's your proposed amendment.
Yes, sir.
Is there a second on the amendment? It's been seconded. Further discussion on the amendment? If not, we'll call for the Welch amendment. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Mr. Jacobs, you have an offer amendment?
I waive.
You waive. All right. Any further discussion or amendments to be made? If not, if there is one, Mr. Weldon.
Mr. Chairman, with respect to the suggestion that Mr. Jacobs made regarding alimony, I think I agree with the comment he made earlier, is that we do need a judgment would be a final rendering by the court, and I think it's pretty frequent that courts make temporary decisions regarding alimony, and they award that. At least that's what I've seen in my courts. And I'd certainly appreciate any comment by Judge Caldwell down there regarding this. But I believe that same language, court orders, awards, comma, court orders, comma, decrees, and comma, and judgments should be added.
All right. Any further discussion on that matter? Oh, wait a minute. Let's finish further discussion. He asked your comments on it. Judge Caldwell, you have any response to it?
I was actually reading something else, Mr. Chairman.
Okay. No problem. No problem. Mr. Jacobs, you had something you wanted to say? No problem.
Well, I would just, I think that needs to be fine-tuned just a little bit, but I propose that and
all right. Why don't we get an amendment on that? Somebody Proposed amendment. You want to do that, Ms. Jacobs?
I'll do that. On line 32 of the bill, before the word judgment, strike the word a and insert in its place an award, comma, court order, comma, decree, comma, or.
Okay, read your full amendment. Be sure we got it right.
So it would read, when an award, comma, court order, comma, decree, comma, or judgment for alimony or equitable division of assets and liabilities is payable in installments. Oh, I guess we also would need to do an amendment on line 34. As part of the same amendment, I'm sorry, we would also then on, well, 34, why don't we just track the language again? So strike judgment, or I'm sorry, don't strike judgment.
Just after such.
Insert before it, after such, but before judgment, insert award, comma, court order, comma, decree, comma, or.
And read your amendment in whole, if you would.
So it would read, starting from the word when an award, court order, decree, or judgment for alimony or equitable division of assets and liabilities is payable in installments, interest on such award, court order, decree, or judgment shall not begin to accrue, and then it continues.
It's offered as the Jacobs Amendment. Number, and you first one. We'll have both sections taken as one amendment. That's the Jacobs Amendment. Do we have a second to it? Was seconded. Any discussion on the Jacobs Amendment? Not the chair calls for the question. All in favor of the Jacobs Amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further amendments? If not, the chair will call the main question, which is a motion do pass as amended to House Bill 347 as a committee substitute. All in favor of, ma'am?
I'm sorry, I just have one question. You all have and in line 11 and you have or on the second page. Do you want to make those consistent or do they need to be?
Could be consistent. If you want to do. On line 11, you're suggesting change and to or, be consistent. I think it reads better from that standpoint because they're not collected. There's a conjunction there which should be separate. So I think if we go back then, look to line 11, and the proposal would be, if you want to offer this, Mr. Jacobs, to change and to or.
So moved.
There's been a motion made.
Second.
Been seconded. So the second Jacobs amendment is to strike through and after decrees and insert or in its place, so that phrase will read all judgments, comma, court orders, comma, decrees, comma, or judgments rendered pursuant to Title 19. Is that correct?
Correct.
Any further discussion on second Jacobs amendment? If not, the chair calls the question. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further proposed amendments? Ms. Travis. I got it.
17, any such award.
To judgment. That does not change that. No further discussion or motions. The chair will call the main question, which is a do pass House Bill 347 as amended as a committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you. Mr. Reeves, I'm going to do your bill next and hold your last bill, if you would, Mr. Hightower. Mr. Reeves, you're on House Bill 245.
295.
295, I'm sorry. Can't see. Why don't you tell us about your proposal, Mr. Reeves?
Thank you, Mr. Chairman. May it please the committee, I have with me here Assistant Deputy to the Secretary of State, David Dove, and he was the brains behind this bill and can help me talk through it if there's any questions or concerns. But this is a cleanup bill at the request of the Secretary of State. It essentially does four things in the four different parts. In parts 1 and 2, some of our current laws on the books predated the LLC entity that we recognize in Georgia. And so parts 1 and 2 essentially make some changes to create some consistency between the now recognized corporate entity of an LLC. Part 3 deals with reinstating dissolved corporations. This came at the request of the Secretary of State due to some concerns that they've had with certain persons who have approached the Secretary of State about reinstating a dissolved corporation, and what they are hoping for is to make some changes so that the persons who are eligible to do that are persons that are registered with the Secretary of State and not persons that are kind of outside of that outside that purview, such as directors and shareholders and members. And then the fourth is basically a change that just deals with.
Where you're referring to now, you lost me on that one. Shareholders.
Yes, in part 3, and I was going to go through
part 3.
In part 3,
section number. Excuse me.
Part 3 deals with reinstating dissolved corporations. The Secretary of State has requested some changes so that the persons who are able to come and reinstate a dissolved corporation, they would prefer it to be persons who are registered with the Secretary of State, such as an agent, a registered agent, or an officer of a corporation, instead of more broadly a director, shareholder, or member. And so that change was requested. I have an amendment. There's a couple of changes that we would like to propose as an amendment to the committee right now on that, and tell me when.
Why don't you talk about first just what you're looking at making further amendment to?
I'm sorry.
Just tell me what your thoughts are as far as what you want to see of further amendments to.
After taking another look at this between yesterday and today, go into part 3.1 on page 5 in lines 149, 150, and 152. We had originally added the word member. We want to strike member, and thus that would move in lines 50 and 52. It would move the "or" to be in between officer and director.
Okay, may I ask a question? I think I understand what you're doing there, because this is dealing only with a corporation that has gone through a dissolution, right?
That's right.
One of the questions I have on the line 46, you recognize the limitation as to those who can apply for this as only being the registered agent or an officer of that corporation, correct?
That's right.
And then down further, we have now using the term of director as being someone who can be authorized to sign these statements.
That's right, because there's two different processes, and the difference is accounted for in the difference in the two processes.
So it's all right as far as director doing it, who may be authorized by the board of directors to be the one to do it? Okay.
Yes, sir. And so then moving over to section 3.2, which is the same issue, reinstating a dissolved corporation, but now we're dealing with nonprofit corporations. Again, looking at lines 173, 174, and 176, we want to strike member, and then in lines 174 and 176, the "or" would shift over to be in between officer and director. So those are the changes with Part 3, or what Part 3 is. To back up, I didn't explain what Parts 1 and 2 do. At some point in Georgia, our laws allowed for a registered agent to be a corporate organization. You can either have an individual as your registered agent, or you can have a corporation. And these laws predated the LLC entity. And so it's never been updated. And so what parts 1 and 2 do, part 1 adds into the definitions foreign LLC and then just regular LLC in several places just to make those definitions consistent. And then in part 2, it inserts into where it's discussed what types of corporate entities can serve as registered agents. It inserts LLCs into that language so that it's consistent with the rest of our code. And then moving back to the end to Section 4, this is very simple. Right now, if the Secretary of State is served, the law requires that 2 copies have to be served, and at the request of the Secretary of State, we would just like to reduce that to 1 because there's no need for 2 copies to be served.
Thank you. Anything further you'd like to add to it?
No, Mr. Chairman. We just echo Representative Reeves' comments and fully support this bill as a measure to provide some improvements to the corporations code.
Thank you. Mr. Weldon.
Thank you, Mr. Chairman. To the author of the bill, if there's only 1 copy of the complaint that's served on the Secretary of State, how does the Secretary of State plan on providing certificate of service or an affidavit of service to the court?
It's my understanding that currently 2 copies are left with the Secretary of State, and they don't need the second copy. Is that correct?
That's correct.
Can you just describe how the Secretary of State provides notice of service, or I guess a entry of service or an affidavit of service upon the defendant?
Do you mind if Mr. Dove answers that?
I don't mind at all.
Okay.
I'll be glad for him.
Currently, it's just the first copy of service that's used. The second copy is it's not needed. As far as the specifics of exactly how that process works, unfortunately, I'm not familiar with all the technical issues that are implicated there. But our Director of Corporations only requires that single copy, and would be more than happy to provide some additional.
Well, I think we're in full committee today. I'd like to know how the Secretary of State is going to provide to the court a written document that provides that the service of that complaint was attempted to be served or served on the defendant. I know this is an issue where if you can't get the defendant, you serve the secretary.
Exactly.
But I don't want to see a good complaint get lost because we mess this up.
Yes, sir.
I think you're looking for what you have is the proof of service by the Secretary of State being filed back with the court, and that comes as a result of needing the copy served on the corporation, and the one that is the verified complaint coming back by the Secretary of State to the court.
Exactly. It's my understanding that's how it's supposed to occur, and that's why the 2 were sent. One goes to the defendant or the corporation, and the Secretary of State gives proof of service with a duplicate copy of the complaint they served on the defendant and sent it back to the court.
It's I'm sorry. It's my understanding that the copy that's served with the Secretary of State is entered electronically, and then the paper copy is still. So that's the file copy for the Secretary of State.
So okay, well so what you guys do is you scan it, and then whenever you file something with the court, you just print it out again.
Or we then have that other paper copy, the original copy that we can use for that purposes. But
if you get 2 copies of the complaint.
Well, the copy is scanned in it for our records. We can keep the electronic copy. And,
Sure.
And then the paper copy can then be served to the court or used for.
Well, which one goes to the defendant?
Excuse me, I had that backwards. I believe the paper copy goes to the defendant, and the electronic copy would then go to the court.
Well, in Catoosa County, we don't have electronic filing. And I don't know many other courts other than
the Secretary of State's office, I believe. What you talking about using electronic form document?
Yes. Mm-hmm.
I think we'll get to issue on that.
Okay.
Mr. Welch, I believe.
Thank you, Mr. Chairman. to Mr. Dove, I just need a better explanation for why we're making the change of removing a shareholder as someone that can, reinitiate the corporation. This is in Part 3 of your bill, of the Representative's bill, Section 3.1 and 3.2. Why is it that we're making another officer of the corporation the person and removing shareholder from that equation?
Yes, sir. Yes, Representative. So what we're doing is we're shrinking the population of members of individuals in a corporation that can reinstitute a corporation when it's been administratively dissolved, and we're limiting that pool of people to individuals that we have record of in the corporate filing or in the LLC filing, as it is. Under the current law, a shareholder can come in for an administratively dissolved corporation and reinstitute that corporation. There's no filing with our office for us to know, whether that shareholder, whether a 2% shareholder or 51% shareholder.
Mm-hmm.
And by shrinking this, it allows us to get a population that we can verify that these individuals are affiliated with that corporation.
Well, Mr. Chairman, may I continue?
Please continue.
The concern I have is that a shareholder typically has made an investment in the corporation, and a member may or may not have that investment. They may just be an officer. They may have received some salary for the corporation, but a shareholder has typically a financial stake in the corporation, and also may be seeking to revitalize provide the corporation for whatever investment, to retrieve whatever investment they've made into it. So I'm concerned about striking that language and substituting. I don't have a problem with including member as as one of those officers that could revive the corporation, but I just have pause over striking shareholders. And if the issue is registration with the Secretary of State, there may be a different solution to that problem, in that rather than eliminating a shareholder's right to revive a corporation and recoup some investments, there may be a reporting mechanism that can be done back to the Secretary of State, or a way in which the shareholder can issue proof of his ownership of shares in that dissolved corporation, so as to satisfy the Secretary of State that's a bona fide shareholder. Those are just my concerns with the measure. Thank you.
Further questions of the presenters? Thank you. That's done. Do we have anyone else who would like to address the committee on House Bill 295? If not, we'll close all further public comment. The bill is now in the rest of the committee. Do we have discussion among committee members regarding House Bill 295? Mr. Weldon.
Mr. Chairman, I'm concerned about the provision for service. I think what the Secretary of State's office is trying to do is to go more to electronic processes, which I think is a more efficient way to handle the large volume of documents they have going through there. But what I see here is that what they're going to end up doing is instead of having two copies, they got one copy, and then they'll scan it. They have to, first off, I'm assuming it'll be stapled. They take the staple out, scan it, restaple it, then go have it sent. They'll send the service copy out to the defendant, and then they'll have to print a copy to serve on a court if you live in a rural area like I do in Georgia. And until we have every clerk of court in the state accepting digital copies, the Secretary of State is going to have to print at least one county's proof of service out. At least if what I would call a good or best practice, they're going to say we served the attached Exhibit A complaint upon the defendant in accordance with law.
We'll entertain a proposed amendment, proper time on that. Further discussion. I I think the chair has also, Mr. Wells, some concern about removing shareholder on lines 149 and 152. I could see the circumstances where you have a corporation been dissolved for several years. You really don't have perhaps someone who would officially sit as a officer or registered agent of the corporation because it has been dissolved. The only one who really has a standing that might be considered to make this affidavit would be a shareholder. Is that what your concern is? Yes, sir. All right. Further discussion among any of the members of the committee? If not, the chair will entertain a motion. Being no motion.
I got a motion.
What's your motion?
Chairman, on line 233.
No, I'm asking for a motion on the bill at this time, not on
do
amendments.
pass. A motion do pass.
We have a motion do pass. Is there a second to the motion? It's been seconded. All right, do we have discussion on the motion or amendments?
I have an amendment.
We recognize Mr. Weldon for an amendment.
On line 233. In LC 37-191-1901 ER, line 233, where it strikes two copies, the words two copies, and inserts a copy. Just delete the words a copy, which are underlined, and unstrike it.
What you want to do is delete the change that's being made at that line.
Yes, sir.
Delete the change.
There and in line 267 and
so
249.
Your motion would be to delete the changes on line 233 and 249 and leave it as previously stated.
Yes, Mr. Chairman, and 267.
Hold on. Mr. Jacobs?
Just delete the whole part.
Crux of that amendment, Chairman Weldon, to just delete Part 4 of the bill and renumber Part 5, Part 4.
Good point.
That states my amendment much better.
That's right. So amendments on that portion.
I'll second that restated amendment.
Thank you.
So the motion is to strike the section identified as Part 4 of the bill, which begins on line 221. That strike will be all the way through Part 4 to line 273. Correct?
That's it.
Any discussion on the motion? That is the Weldon amendment. All in favor of the Weldon amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Mr. Welch.
I'd like to propose an amendment, Mr. Chairman.
All right.
That is to delete Part 3 of the bill.
So again, there would be the question about the authorized parties who will make the filings with the Secretary of State.
There's one thing that gives me pause about that, Mr. Chairman, and that is Section 3.4, and so I'm open to being more specific about the deletions and deletions of 3.3-1-2-3, and leaving 3-4 if that particular section is important. But I need to know a little bit more about that.
Hold on just a minute.
Basically, it's tying in that these changes would be applicable to the whole section because it's 603.
Mr. Dove.
Yes, Mr. Chairman.
May I ask you a question, please, on that Section 3.4? We're still dealing within the corporation code, are we not?
Yes, Mr. Chairman. In fact, Section 3.4 is subsection B7, which is in the same code section as Section 3.3. And
But do we have a whole different chapter that deals with the LLCs, we'll call it, and their dissolution. Why are we referencing LLCs in this area?
This, Mr. Chairman, this particular subsection of the code is applicable to LLCs, and so that's why 3.4 is present there.
I'm going to, as chair, I'm going to exercise my prerogative and refer this back to committee for further work. It's got some questions here that we're not able to really resolve in committee as a whole on the bill.
Sure, understand.
All right. So it came out of which committee? Fleming. All right. So we'll refer it back to the Fleming committee for some further discussion. That's you all through it. All right. Let's do it that way. Then we'll hopefully have it back by Thursday for you.
Okay. Thank you, Mr. Chairman.
Thank you.
Thank you, Mr. Chairman.
Keep the bill as is, or
Huh?
does that mean we keep the bill?
Keep the bill as is. Yeah, right now.
So no amendments.
No amendments.
Going back to session. Okay.
Chair exercises prerogative to hold the bill up. Next we got is, I don't have the bill in front of me. Next we have House Bill 303. And that's the tie tower. Come on back up. Thank you. Yeah. All right. Address the committee on your House Bill 303, Mr. Hightower.
Yes, Mr. Chairman. And Mr. Chairman, I would like to start off with saying that Ms. Bagwell and Mr. Potter have both gone out of their way to communicate with me since our last hearing, and I greatly appreciate their counsel and communication. Also, at the last meeting, I did kind of go at them a little bit for not communicating with me prior to that meeting, but little did I know they had actually left a message. They said with my office. I didn't get the message, but I trust after dealing with them that they actually did do that. So they've been great since then. I want to apologize if I called them out in any way. That was not my intent. My intent was just to encourage them to work with me, which they've done since that hearing. So I greatly appreciate them. Also, Mr. Chairman, I've spoke with Georgia Chamber. They have a letter in your packet right now. The thing that they were focused on is the attorney's fees, I believe. That's been changed, Mr. Chairman, as you all know. Working with you and Chairman Jacobs, we made it so that bad faith would have to be proven before they could get attorney's fees. So they've asked that you currently ignore that letter at this time and just set it aside. Is that accurate? I don't believe. I believe they're just. That's right. And is that an?
We'll hear from them as if their position is
accurate.
That's Mr. Hightower.
Jeez.
You go ahead and address the bill. You go ahead and address the bill, and I'll let them speak for themselves.
All right, Mr. Chairman. Mr. Chairman, this bill started off with, as a personal thing for me, to give the full committee a little bit of background. The subcommittee's heard this many times already. This started off with a client of mine that had some issues with obtaining her policies on a bad faith claim, and we saw I've seen this process be abused at times, and so I came to this wanting to make the penalty for bad faith a little bit stronger than what it was. And for those that on this committee that don't know how the bad faith works, do you want me to go into a full example, Mr. Chairman?
Go ahead.
For everyone. Let's say if Mr. Maber and I get into an accident, and it's Representative Maber's fault, and I go to Roger Bruce isn't here, so I can't use him. And Mr. Maber was a second signer on the bill, so I thought it'd be good to use him. We have an accident with each other, and I write a demand to his insurance for his policies. I also at the same time write a demand to my insurance company, my own insurance company, for uninsured or underinsured coverage that I have. Let's say that we both have the state minimum policy requirements. Mr. Maber has $25,000 policy limit. I have a $25,000 policy limit on my UM policy with my own insurance company. When I write those demands, obviously, I'm going after trying to get those funds back to me to recoup whatever I lost in that accident. To get to what we're dealing with here is the bad faith part, dealing with my own insurance company. I first would have to prevail in a lawsuit against Mr. Maber's insurance company. So I would go to, the way this could work out is I could go to Mr. Maber's, first off, my insurance company would deny my policy. All right, that's what would kick this off. Then I would go to Mr. Maber's policy, and Mr. Maber's policy, they may be wanting to settle with me, but I would not be able to settle with them because I'd have to go through a suit with Mr. Maber, because in one of the beginning obstacles to getting to a bad faith claim is I have to win my initial action, which in this example would be against Mr. Maber's policy. Once I win that, let's say the judgment would be for $100,000, I think is the example I used before. Judgment in our suit was for $100,000. I would get the $25,000 in his policy. I would then typically get the $25,000 that was on my policy, because that was under my coverage, and obviously I was underinsured based on the judgment. So usually a policy would then pay. But the bad faith comes up when my insurance provider didn't provide those policies when I first made that demand. So then I would go to show that they did so in bad faith. And I would have
you say did provide those policies.
Didn't provide my policy at the time of my demand.
Coverage under the policy.
That's right, Mr. Chairman.
Okay, so you got a stacking issue.
Yep. First I have to win with him.
25 primary, another 25 uninsured motorists.
That's what I would get from that. That's what I would get from my coverage. Not stacking. That's just what my coverage was for my Whenever it goes to that point, if for me to try to go against my own insurance company for bad faith to show that they did not pay my policy in a timely manner as we were contracted to do, I would have to then show that they acted in bad faith. The current law is if a judge or jury finds that they did act in bad faith, they're only liable for 25% of the underlying policy, not for the full judgment, which judgment could have been for $100,000 in this situation. They're only liable for 25% of the underlying policy, which is $25,000. So they're on the hook for roughly $6,250. And for me, when evaluating these cases, I didn't think that that was enough of a hook for insurance companies to truly act in good faith, because I just didn't think that was enough of a penalty. They had been found in essentially willful bad faith by court. You've already had to win one lawsuit to get to be able to have this lawsuit, and they've then been found in bad faith. And so my goal was to up that penalty. And I started off with 100% of the judgment, and we've come down from that a great deal. And what we have here today before you, and what I'm asking y'all to consider, is if an insurance company is found in bad faith, that the penalty would be $25,000 or 25% of the underlying policy, whichever is greater. By doing it that way, Mr. Chairman, any policy over $100,000 would not change under current law, but it would protect. It would give a greater penalty and greater protection. In the subcommittee, we flesh this out a lot there to some of the smaller policies where I think you see a little bit more of the abuse. So in a $25,000 policy, which would be the minimum there that someone could have, it would be a 100% penalty, because it'd be $25,000 or 25%, whichever is greater. And I want to thank Chairman Welch, Chairman Jacobs, and Mr. Chairman, you yourself for helping me work through this, and I think it's addressed a lot.
Yes, sir. Mr. Jacobs?
Yeah, I would just add to that, and I would like for anybody who testifies after this to tailor their testimony to these two amendments that are likely coming. One of them would be, I mean, we spent a lot of time working on this bill, a lot of time.
Yeah.
But one of them would be on lines 12 and 13 to strike the language. These are not amendments at this time, obviously, but I'm just putting on everyone on notice that are likely to be proposed. To strike the language reduced to judgment against an uninsured motorist, that is. And the reason for this amendment is that language was inserted in kind of some discussions after subcommittee. Obviously, a demand for coverage can be served before a judgment is rendered, and it certainly is not the intent to, only deal with demands that are served post-judgment against the uninsured motorist. So that's the first amendment that would be proposed. And then on line 28, after pursuant to, we would insert subparagraph B of in front of paragraph 1. So it would prevailed on a claim pursuant to subparagraph B of paragraph 1, and then you could get attorney's fees.
For bad faith.
Right, because subparagraph B of paragraph 1 deals with the penalty, which requires proof of bad faith. So you would have to prove bad faith in order to get the attorney's fees as well. We had, on subcommittee, I had a significantly lesser penalty than where we are now. And the idea was to take bad faith out from under as kind of a counterbalance to that, to take bad faith out from under to take attorney's fees out from under the bad faith umbrella and make it easier to get attorney's fees. Since we've heightened the penalty, I think we should put attorney's fees back under the bad faith umbrella where they originally were. And so that's going to be the second amendment that I'm going to
Mr. Chairman, we talked about both those amendments at length. Those are.
May I ask a couple of questions to get some clarity? I'm not handling coverage for a long time, but the example you gave is one where you've gone through and had a judgment against the party who caused the injury, and you're now with your judgment saying, I've got $25,000 coming from Mr. Mabur, but I've also got $25,000 uninsured. What would be the basis for a uninsured carrier to not pay when you have a judgment?
And that actually goes to taking this language out. Typically, that would not happen. Most of the time, if you have a judgment and because after the judgment, you know whether or not it was uninsured.
Where I'm thinking most of it would be applying is if Mr. Mabur hits you and he does, and there's no question of liability, and he either doesn't have insurance, he's uninsured, and you've got coverage to your policy.
Sure.
And they say, well, we just doubt the liability, we're not going to pay until you go after judgment. Then you have your 60-day letter. Is that right?
You can.
As I read the law, if that's where it says you make a written demand on your insured, and there's let's say clearly liability, and they fail to pay, then you bring an action to receive your coverage for your uninsured motorist. You got to also sue the party, haven't you?
I have to sue Mr. Mabur in that situation.
Okay, so that's where your bad faith would come in.
Yes, sir. And even if there is no Representative Mabur, it's a hit and run, I still have to file a suit against the John Doe.
And in fact, and true, that's where you have an unknown party. And in fact, the uninsured motorist coverage may be sitting as a carrier defending the action on behalf of Mr. Mabur. Is that right? Don't they do that?
Could happen, yes.
Could happen. Okay. So the thing we're trying to focus on is this issue of, well, you're doing all this in bad faith. You've had a clear liability. You want to resolve this thing. Let's do the right thing. Pay it.
That's right.
And let's get it cleared up.
And that's exactly correct, Mr. Chairman. And it's very focused. I mean, we're dealing with a very focused area of the law, a very focused penalty. And the reason that I focused it there is because that's where you see some of this bad faith. Okay. And that's why I want to heighten that penalty a little bit.
All right.
But you're exactly right, Mr. Chairman.
Any other questions of the presenter? Mr. Welch.
Thank you, Mr. Chairman. So, should this bill get a favorable recommendation from the committee, what ultimately with these amendments that you're proposing, and I think those that are also being proposed by Chairman Jacobs, is there's going to be a little bit more teeth in the law to incentivize on the lower end scale the lower end policyholder to have some protection from his or her insurance policy or insurance carrier, so that if they're injured, the carrier will step up, hopefully, and provide some level of monetary care while they're trying to pursue the action against Mr. Mabra, and in a sense give them an opportunity to bring that action and be successful in it.
That's correct.
While not losing their job, hopefully, and not suffering any other harms that might result.
That's correct.
Thank you.
And the way that we did that, because it became apparent through the subcommittee that really it seems as though these issues revolve around some of your lower end policy limits. The way we structured it was that 25,000 or 25%, whichever is greater. So we left your higher end policies; those are going to be untouched, because when you get to those policy limits, you're already dealing with a great bit of money anyway. So it really helped those low end policies where the penalty to the insurance company was very minor. So
anything further, Mr.
I thought
Welch?
it was a good compromise.
Mr. Weldon?
Thank you, Mr. Chairman. And I'd like to make a comment regarding the statement of Mr. Welch and to the author of the bill. This requires right now, the way the state of the law is, carriers really don't have any liability until after there's a judgment rendered, correct? And so they can lay back and say, hypothetically, they could just lay back and say, well, we're going to let the liability carrier do all the work and do the adjustment and do the investigation, and we're just going to work with them, and they just kind of sit back and let them do all the work. This puts the burden, this requires the insurance that the victim paid a premium to obtain. This puts them on notice that they could be facing, they could be paying out at least $25,000 or 25% of a judgment that's rendered against the tortfeasor, in your example, Mr. Mabra, and gets them in the game, or it hooks them in and puts them in on notice. They better be working to investigate, make their own investigation, and their due diligence in investigating and adjusting the claim as is necessary and as the claim warrants. Is that the point of this legislation?
That's correct.
Anything further of the presenter? If not, we'll hear from others who want to speak on House Bill 303. Come forward. Thank you.
Hello, I'm Emily Bagwell, and I represent the Georgia Association of Property and Casualty Insurance Companies, and thank you to Representative Hightower for the comments earlier. Mr. Potter's not here today. He was unavoidably away from the Capitol, but as those of y'all know, I've worked with many members of the committee, and various members of the property and casualty insurance groups have as well, and y'all are probably a little bit tired of hearing from us on this bill. So I won't go into all the comments that we went into at subcommittee, but just wanted to say that we do have concerns about the general changes in the law. This is a very complicated area of the law. Although this change is a targeted change, it is a complicated area of the law because many times there are issues of what the degree of liability is. The coverage may not always be just one carrier and one liability carrier. Many times there are other companies involved as well, multiple carriers. As a matter of fact, I think those of y'all who work in this area would say that one of the burdens is to find all the possible coverage out there. But in addition, many times there are situations because of questions on coverage and valuation of a claim that companies may offer some of the policy limits but not the entire policy limits. So those are just sort of background comments to say it's not a situation where companies are frivolously refusing to pay claims. At least that's the perspective of the insurance world. We are just now getting these changes. I just saw them, as many of y'all did, just a few minutes before the committee hearing. I appreciate those of you who have worked on doing this. I know many of y'all have put in a lot of hours on making these changes. So I just want to reiterate our general concerns. I've sent this to people who practice in this area to get their comments as to what the actual impact would be and to the specific proposals that we have here before us today.
Which ones are we talking about, Ms. Bagwell, as far as changes that were made? I know there was a bill that came out of subcommittee, and from that bill and subcommittee, as Mr. Jacobs says, there was an insertion of a clause here that reduced the judgment against an uninsured motorist. That is,
Yes, sir.
that's what we're talking about, having not been put in by a subcommittee and removing at this time.
Okay. And I heard that. I guess when I talked to some of y'all earlier today, it seemed like if the targeted change is simply moving to $25,000 or 25%, dropping that change into the current law, although we don't agree with it, we would certainly know where we are, and
Right.
there's a good bit of case law interpreting that, and I think would get to the meat of what Representative Hightower is concerned with.
Okay. And the issue on attorney's fees is only applicable if there's been a proven bad faith conduct.
And I appreciate the clarification that Representative Chairman Jacobs made earlier a few minutes ago about that proposed, that does address the concern that I had raised earlier today, and I appreciate that.
Is there anything you want to
No, sir.
see modified, or just ask what
I think everybody knows what I'd like
All
to
right.
see modified, but I think the concern that I had raised earlier today about the bad faith is addressed by the issue or by the change that Mr. Jacobs raised.
Thank you, Ms. Bagwell. Chamber, I see you sitting out there. You want to respond to your letters in file, and
I think Representative Hightower stated our position at this time. We are assessing the substitute, so I ask that you ignore the letter.
All right.
And fold it.
anyone else in the audience wish to address the committee on House Bill 303? If not, we'll close off further public input. The bill is now in the breast of the committee, and Mr. Weldon, you wanted to speak?
I'll withdraw it, Your Honor.
All right, Mr. Welch. Your Honor.
I make a motion, recommend do pass.
Okay, we got a motion. Do pass. Do we have any further discussion or amendments, Mr. Jacobs?
Two amendments, Mr. Chairman. The first amendment on lines 12 and 13 of the bill to strike the language reduced to judgment against an uninsured motorist, that is. So this would
Cool.
do away with what appears to be a new requirement that you have a judgment before you serve the man.
All right, so that'll be Jacobs Amendment 1.
Second.
Or Jacobs Amendment, we'll call it this time. Any discussion on, is there a second to that?
Second.
Second to that motion, all right. Any discussion on the Jacobs Amendment? If not, yes, sir, Mr. Weldon, excuse me.
I guess in the following underlying language says, and the applicable automobile liability or motor vehicle liability policy. Aren't we in 33.711? And this is talking about uninsured motor coverage,
Yes,
right?
sir.
So it'd be, when I think liability policy, I don't think UM policy.
Right.
think it's included.
It would be the uninsured motorist coverage in the applicable policy, and we imported that language in subcommittee from elsewhere in this code section. Actually, I think the very beginning of the code section.
Right.
So term applicable automobile liability or motor vehicle liability policy is referencing the applicable, meaning uninsured motorist coverage of the policy that's being applied.
It isn't covered by this code section, which is the other language that's right there, unless it's uninsured motorist. That's right.
Let's take the first phrase. We have the proposed Jacob Amendment. It's been seconded.
Okay. I
Any
don't have
further
the whole
discussion on
statute
that
sitting
motion?
there,
Did
so-
you have a discussion, Mr. Fleming? Thank you.
Okay.
Mr. Chairman, thank you. And this question may be to the offer of the amendment, Mr. Jacobs, but I suffer from having just come from another committee, having to commit a bill, having to bring a bill, so I missed the discussion. What is the substantive effect of your motion, your amendment?
This language was inserted after subcommittee, and it appears to suggest that you have to have a judgment before serving a demand under the uninsured motorist coverage in the first place, and that
Okay.
never was the intent.
Okay. So it's really just putting the law back to where we think it is now.
Correct.
Thank you. Thank you, Mr. Chairman.
Sure. Any further discussion on the Jacobs Amendment? Now the chair calls the question. All in favor of the Jacobs Amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries.
Second.
We have a second amendment, Mr. Jacobs.
On line 28 of the bill, to insert after pursuant to the words subparagraph B of, and then continue on. Okay, so it'd be, who has prevailed on a claim pursuant to subparagraph B of paragraph 1 of this subsection. And this has the effect, because subparagraph B deals with a bad faith finding, of putting attorney's fees back under the bad faith umbrella.
Been motion made and seconded for the Jacobs second amendment. Everybody understand the amendment? Any discussion on the amendment? Not, the chair calls the question. All in favor of the Jacobs second amendment signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further amendments? If not, the chair will call the main question, which is a due pass recommendation on House Bill 303 as a amended and committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Mr. Fleming, is that your? Sorry. Okay. That will complete the business for the day. We referred back. Were you here, Mr. Fleming? We referred back House Bill 17 to your committee. Okay. And if there's nothing further, we'll stand adjourned.
Thank you, Mr. Chairman.
Thank you. Huh?
And 295 was referred.
Yeah.
Very quick question.